Mr. Ford said to the press that his clients plan to appeal the decision of the learned Chief Justice. Again, I say that these are attempts at delaying the hearing and determination of the committal proceedings. Again, I say that this is part and parcel of a plan expressed publicly by one of the fugitive offenders to stretch this matter out to last beyond 5 years. Mr. Ford himself admitted when he spoke to the press that the appeal itself does not operate as a stay. Mr. Ford telegraphed, perhaps unwittingly, that the filing of the appeal will be accompanied or is part of and will be accompanied by some strategic steps. So clearly to my mind, it is not the merits of the law that is being prosecuted, but it is a strategy, and that's coming from the horse's mouth. The client himself and now the lawyer paraphrasing and telegraphing that strategy. And what is that strategy? What can that strategy be? Obviously, to delay and protract the committal proceedings from being concluded. And I hope that that will not happen. The magistrate has already said that the questions that they have posed to her are frivolous and vexatious. Mr. Ford himself has admitted in writing and orally before the Chief Justice that he is canvassing those very matters which he canvassed before the magistrate in these proceedings. The judge has rejected it as frivolous and vexatious as well, in essence. That is what the essence of the ruling is. Now, if the magistrate has already ruled that they are frivolous and vexatious, now the Chief Justice has ruled similarly. I can't imagine the magistrate can have a basis for delaying the matter simply because an appeal has been filed, since that magistrate has already made a finding of law that those very questions from which there is now an appeal are frivolous and vexatious. So we are going around in a circle, and there is a classic case of abuse of process. And that's what I've been saying from the inception. I heard Mr. Ford say that challenging the committal ruling or the committal proceedings after they are concluded is not an effective and efficacious remedy. Those were the two words he used. Because the committal order would have already been made and his clients would have already been placed into custody. Now, the flip side of the coin is the law that Mr. Ford is challenging was enacted in 2009. They now choose to challenge that law. Many persons have been committed and extradited based upon that very law. As late as 2018, a judge of the High Court, who is now in the Court of Appeal, examined those very arguments, examined those very challenges to that same legislation, and dismissed them. So that is the state of the current law of Guyana, having been examined by courts and pronounced upon, if that is the state of the law, that is the law that must be applied. And every judicial officer has a duty to apply that law until it is changed or until a court pronounces otherwise. And you have to follow the procedure set out in the law for the court to pronounce otherwise. And that pronouncement should properly come after the committal. Now, let us say that Mr. Ford succeeds and a court subsequent to the committal says that the law is unconstitutional. Then that court would be obliged to quash the committal order, and his client would get the remedy that they seek. But the law operates with a machinery of procedure by which it is administered. And the procedure has a chronological way in which it unfolds. They want to upturn the whole procedure, put what is at the end at the beginning to suit their clients. The law is not going to be turned upside down for one litigant or two litigants. The law must apply equally to all citizens in the same way. So this attempt again, as Mr. Ford says, this strategy that they are pursuing, I believe ought not to yield any success because it is contrary to the spirit and policy of the law. It's contrary to the law itself. So I wouldn't worry too much about that.
Is there any way that
I am saying that it ought not to. An appeal itself doesn't operate as a stay. That is why they went for a stay when they challenged the constitutionality of the 2009 amendments, and that stay was refused. So the mere filing of an appeal can't bar the magistrate from proceeding. The magistrate should proceed unless a superior court injuncts her or prohibits her from so proceeding. And no such application has been filed, and none is being said that they will be filed. Mr. Ford apparently is hoping that the mere filing of the appeal itself and the magistrate would stay her hands. Of course, the lawyers appearing for the US government will address the magistrate on that matter tomorrow.